Well, good morning. Thanks to everyone who made it out. I have nothing but admiration for anyone who can get up early on a Saturday morning to come and hear a panel on the rule of law, especially those who were involved in festivities last night, so bravo. Thank you for coming. The subject of my talk is Aboriginal rights and the rule of law. As Joanna alluded to, there is arguably no other area of law that has changed to such an extent in the past 2.5 decades in Canada as Aboriginal law. Most of the current day content of Aboriginal rights and title is the result of judicial development since the 1990s. Moreover, entirely new constitutional doctrines like the duty to consult and accommodate have been developed in the past couple of decades. This rapid change and the relative novelty of the bulk of the judge-made law in this area has made it particularly susceptible, let's say, to contemporary judicial attitudes. In particular, I argue in my paper that the current state of Canadian Aboriginal law reflects the diminished importance that jurists now attach to the rule of law. This contemporary judicial skepticism about the rule of law was recently given voice in a characteristically candid manner by my former boss, Justice Rosalie Abella, the longest serving member of the Supreme Court of Canada. The Globe and Mail reported in July of 2016 that the phrase, "the rule of law," annoys Justice Abella, since it is consistent with great injustices, like apartheid and the Holocaust. This somewhat glib statement of hers seems to reflect a kind of popularization of scholarly work associated with the critical legal studies movement. To simplify things greatly, this school of thought is generally hostile to the idea of the rule of law because it can justify the maintenance of systemic forms of oppression. I should say that I do not think that Justice Abella is alone in this stance. I just think she is more open about it than her colleagues. As an aside, I think this helps to underline that ideas do matter. It may be tempting to dismiss what goes on in the legal academy as irrelevant, but it filters through to judges and lawyers over time. And that's, of course, part of why the Runnymede Society is so important. So let's start out with some basics. What do we mean when we refer to the rule of law? In its most general terms, the rule of law connotes the idea that government coercion is constrained by laws rather than being subject to the discretionary whims of the powerful. While there's some disagreement as to the precise boundaries of the concept of the rule of law, there is considerable overlap among competing definitions. F.A. Hayek, echoing the 19th century jurist A.V. Dicey, identifies 3 core attributes of the rule of law. In order to conform to the rule of law, for Hayek, laws should be universal, known, and certain, and apply equally to all. Laws should be universal in the sense that they should not specifically target particular parties. They should be known and certain so as to make it possible for parties to comply with the law by structuring their conduct in accordance with clear rules announced in advance. And laws should apply equally to all. Similar cases should be treated similarly without arbitrary or class-based distinctions. The concept of the rule of law has traditionally been seen as foundational in liberal societies such as Canada. It would have historically been perhaps the central value in the worldview of Canadian judges, rather than something to be skeptical of. Indeed, the rule of law is one of the concepts that transcends the distinction between modern liberalism and classical liberalism. It is important to small L liberals of all stripes. Let's take a look now at some contemporary Aboriginal rights jurisprudence before going on to assess some of this in light of the rule of law. For the sake of brevity this morning, I'm going to focus on 2 doctrines in particular, Aboriginal title and the duty to consult. But I do think the critique that I'm setting forth here does apply more generally than just with respect to those two doctrines. So we'll start with Aboriginal title. The doctrine of Aboriginal title to land has a long heritage in common law settler countries, dating back at least 2 centuries. It allows an Aboriginal group that has historically occupied a given area of land to claim title to that land. In this sense, it is broadly consistent with the common law of real property, under which long-held possession of land can ground a claim to title. It's worth emphasizing this. The doctrine of Aboriginal title is not per se inconsistent with the rule of law. In fact, the rule of law, and in particular, the principle of equal treatment under the law, demands that Aboriginal occupation of land be legally recognized. However, the way the Supreme Court of Canada has chosen to develop the doctrine of Aboriginal title has given rise to needless uncertainty and unequal treatment of Aboriginal property holders. Beginning with the 1997 case of Delgamuukw, the court has issued a series of fairly dramatic decisions that effectively designed a novel form of property interest in the abstract. There are a number of unique features of Aboriginal title as a property interest, each of which was either invented or developed in unhelpful ways by the Supreme Court of Canada in recent years. I'm going to focus on 2, inalienability and the so-called inherent limit on use. So first off, land held under Aboriginal title is inalienable. It can't be sold to private parties. It must be conceded that Aboriginal title at common law has long been seen as inalienable except to the government. And this feature of Aboriginal title may arguably enhance the self-government interests of Indigenous groups by ensuring the maintenance of a contiguous land base under group control. But if the purpose of the restriction on alienation is to reinforce Aboriginal self-government, it should be interpreted in a flexible manner in deference to Indigenous autonomy and land management powers. However, the court has gone in the opposite direction, expanding the scope of the restraint on alienation in new and uncertain ways that could drastically limit what Indigenous groups can do with their own land. In Chilcotin, the court states that Aboriginal title to land cannot be alienated except to the Crown. So far, so good. But then it goes on to say that land also cannot be encumbered in ways that would prevent future generations of the group from using and enjoying it. There was simply no basis in the existing jurisprudence for this vague additional restriction regarding encumbrances. Encumbrance is a highly general term that could include everything from leases to easements to mortgages. That's a big problem because leasing especially is one of the major tools First Nations can exercise for economic development. This new restriction on encumbrances was introduced by the court of its own initiative without any party arguing for it. Aboriginal groups may have to wait years or even decades before subsequent litigation clarifies what types of leases and other encumbrances they are going to be allowed to engage in on land that is recognized to belong to them. The second unique feature of Aboriginal title that I'm going to talk about is the inherent limit on the use of Aboriginal title lands. In Delgamuukw, the Supreme Court of Canada introduced this entirely new restriction on uses. This is described in a number of different ways in Delgamuukw and the later Aboriginal title case of Chilcotin. In Delgamuukw, we are told that lands subject to Aboriginal title cannot be put to such uses as may be irreconcilable with the nature of the occupation of the land and the relationship that the particular group has had with the land. In Chilcotin, the court states that Aboriginal title land cannot be developed or misused in a way that would substantially deprive future generations of the benefit of the land. To be blunt, no one has any idea what that means. It has no clear parallel in any other common law jurisdiction that recognizes the doctrine of Aboriginal title. As with the alienation restraint, Aboriginal groups that establish a claim to Aboriginal title may have to live with this uncertainty for a long period of time before future litigation establishes what exactly they are entitled to do with their land. Moreover, no party ever asked the court to create this unusual and paternalistic restriction on the use of Aboriginal title lands. The court did so completely of its own initiative in Delgamuukw. In setting out the unique content of Aboriginal title, the court saw itself as recognizing the common law with Aboriginal perspectives. However, the court did not engage in any serious way with specific Indigenous laws and institutions relating to land in arriving at the content of Aboriginal title. The court seems to have simply relied on the vague notion of an Indigenous connection of land to come up with unique restrictions that it designed itself and then unilaterally imposed on Canadian Indigenous groups. That it did all this despite the obvious cost to legal certainty indicates as much as anything what little weight contemporary judges sometimes attach to rule of law values. In its modern Aboriginal title jurisprudence, the court has designed a property interest rife with uncertainty. The main parties that will suffer the effects of this uncertainty are, of course, Aboriginal groups that establish a claim to Aboriginal title, though effects will also be felt by any party that seeks to engage in dealings with Aboriginal title holders. In addition to creating a doctrine that is not known and certain, the court has also arguably failed to meet the other rule of law standards of universality and equality under the law. Only Aboriginal property holders are subject to these uncertain restrictions on use and alienation. Non-Aboriginal property owners, even those whose title is based on long-standing occupation of land, are entitled to the benefit of well-defined common law proprietary land interests that have been shown to work for a wide range of uses of land. While the distinct circumstances and priorities of Aboriginal title holders might justify some legitimate doctrinal differences with the common law, it is unclear how these particular restrictions on Indigenous autonomy are related to legitimate objectives. Aboriginal Canadians really have been singled out for a lesser form of property interest. The next area of the court's Aboriginal rights jurisprudence that I'll argue has failed to live up to the rule of law is the duty to consult. The duty to consult applies in a wide and still not fully defined set of circumstances where a government decision could affect Aboriginal interests. For instance, in the key case of Haida Nation, the Supreme Court held that the duty to consult is triggered in cases where a government decision affects asserted but unproven Aboriginal rights. The court in that case established the duty to consult as a highly malleable procedural standard. In setting out the requirements of the duty to consult, the court has relied heavily on the metaphor of a spectrum of consultation. From deep consultation owed in cases of significant impacts on interests protected by strong claims, down to less onerous consultation owed in cases where the impact of a measure is minor or the claim is weak. The duty to consult has given rise to a significant amount of uncertainty and litigation. Two distinct aspects of the duty to consult, I think, have especially fueled this uncertainty. The first is that it is structured as an open-ended standard. This means that the specific content of the duty is only definitively determined after the conduct occurs when it's assessed by courts. Standards are often contrasted with rules whose content is set out in a more complete manner ex ante before conduct occurs. While modern law is of course full of standards, including, say, the common law negligence standard of fault, in tort, the duty to consult stands out for the level of uncertainty it has created for parties. Most standards that are deployed in the law, like the negligence standard of fault, rely on pre-existing customs and practices to fill out the content of the standard and provide guidance to parties. We know more or less what it means to exercise reasonable care in driving a car or keeping the driveway free of ice because we have existing practices we can refer to. By contrast, the Supreme Court, in creating the duty to consult, sought to create entirely new practices. In the aftermath of Haida, a party seeking to understand what the duty to consult entailed could not look to existing customs and practices for guidance. Such a party was instead left with the very general words of the Supreme Court in order to try and predict what courts would require in the future in the wide range of different circumstances in which the duty to consult could apply. A second aspect of the duty to consult that has exacerbated the uncertainty associated with it is the fact that it relates to procedures of government decision-making rather than the substantive rights that parties have with respect to particular resources. You can end up with potentially multiple rounds of dispute over procedure without ever getting to clearly defined property rights that would allow Indigenous groups and other parties to make reliable plans with respect to resources. Liberal political theory, both classical and modern, can help illustrate what went wrong with recent Aboriginal rights jurisprudence, why it matters, and what might be done about it. Legal uncertainty and unequal treatment are seen as problems for a liberal theorist, primarily because of the implications for autonomy or liberty. An individual or group subject to unpredictable rules that are not general in application is less able to make choices free from fear of interference. This is the primary concern that motivates John Rawls, a modern liberal, in identifying the rule of law as an integral part of his scheme of equal basic liberties. This kind of liberty interest is also what motivates F.A. Hayek, a classical liberal, to make the rule of law so central in his work. The rule of law failures associated with Aboriginal title and the duty to consult have clear implications for the liberty of Indigenous groups and individuals, as well as the wide range of other parties that may seek to engage in activities that implicate Aboriginal interests. In addition to these liberty interests, however, Hayek's work provides a basis for an alternative economic critique of why these rule of law failures matter. According to Hayek, most of the information needed for successful economic coordination simply cannot be processed by a central decision maker, even a judge. And this means that it is important to ensure that the law provides parties on the ground with the tools to make economic decisions for themselves with some reasonable degree of confidence that these decisions will not be interfered with in unpredictable ways. And secure property rights are a big part of the key to doing this. On this point, Hayek's theoretical insights have been reinforced by a significant body of subsequent literature in development economics, indicating that well-defined, secure, formal property rights are a crucial factor for economic development. The unpredictability of important aspects of Aboriginal rights jurisprudence is thus not solely an issue for liberty or autonomy interests. It may also undermine economic development, and this is something that has been highlighted in the work of Dwight Newman in particular. Hayek's legal theory also provides insight into the process of legal development that Aboriginal rights jurisprudence has followed, and how this might be related to associated rule of law failures. Canadian Aboriginal law has long been characterized by the sweeping imposition of centrally designed rules on Indigenous communities in a manner that disregarded local traditions, norms, and circumstances. The most well-known instance of this was the imposition of the Indian Act regime in the 19th century, which sought to displace traditional Indigenous laws and institutions. However, the significant legal changes brought about by the court since the mid-1990s also arguably fit this mold. In its modern Aboriginal title jurisprudence, the Supreme Court has essentially designed a new kind of property interest in the abstract and then imposed it on any Indigenous community that might have an Aboriginal title claim, regardless of the particular traditions, values, and circumstances of the community. Likewise, with the duty to consult, the court has set out an abstract framework for consultation obligations without possibly knowing how it would apply to the broad range of decisions that potentially affect Aboriginal rights. This kind of sweeping imposition of rationally designed rules is the antithesis of Hayek's vision for how law should develop. For Hayek, well-adapted legal rules come about through a process of gradual development in a kind of equilibrium with customary norms and practices. This process allows courts to be aware of what approaches work in practice, avoiding issues with unforeseen consequences. The gradual nature of legal change on this approach also helps to ensure legal certainty is maintained and settled expectations are protected. While some legal change in this area was definitely necessary in order to vindicate long neglected Aboriginal interests, the court's approach of imposing entirely new legal regimes designed in the abstract has exacerbated the associated uncertainty. It has created uncertainty that was simply unnecessary. For instance, with respect to Aboriginal title, it's long been recognized that this is a unique interest in land with features that distinguish it from a fee simple. Rather than exacerbating the uncertainty associated with these unique features, however, the court could have sought to define them in a precise manner while avoiding the introduction of new features, new unique features, without any basis in existing practices or jurisprudence. The court could have stated clearly that the long recognized restraint on alienation simply means that the underlying Aboriginal title cannot be sold directly to private parties, but that the Aboriginal group can grant subsidiary interests under their own laws and institutions, as many groups did historically. The court could have avoided introducing completely novel forms of restrictions, such as the inherent limit on uses and vague restrictions on encumbrances on the land. This approach would have developed the law in a direction that provides clarity for interest holders and would have brought Aboriginal title more in line with existing interests in land that have been shown to actually work. Similarly, the legal issues addressed by the duty to consult required legal change that would have inevitably given rise to some uncertainty. The duty to consult deals in part with situations of asserted but unproven Aboriginal claims to rights or title to land. By definition, these are situations in which there is some uncertainty about the underlying rights. Acknowledging that Aboriginal claims persist in spite of past wrongs, necessarily it creates uncertainty. But maybe this is necessary uncertainty. However, the approach that the Supreme Court of Canada took in developing the duty to consult exacerbated the uncertainty associated with outstanding Aboriginal claims. The court's decision in Haida to leave the specific requirements of the duty to consult essentially open has fueled uncertainty in litigation. Rather than a malleable standard based on the metaphor of a spectrum, the court might have instead given a clearer statement about what specifically the duty requires. In doing so, it could have drawn upon existing administrative law doctrines like procedural fairness, rather than trying to design something completely new. Moreover, the duty to consult has proven to be such a potent tool for Aboriginal groups to challenge decisions relating to resource use that it is likely diverting litigation efforts away from substantive rights claims. If a group is able to use the threat of a challenge based on the duty to consult as leverage for impact benefit agreements with resource companies, it has less of an incentive to bring rights and title claims, or indeed to conclude a modern treaty. This is a problem because treaties and rights and title claims generate greater certainty about rights relating to resources, whereas challenges based on the duty to consult do not. To sum up, my argument is essentially that it would have been possible for the court to protect Aboriginal interests in a meaningful way that accounted for past injustices, while at the same time upholding rule of law values that have long been foundational in our system of government. That the court didn't do so leads me to draw the inference that the rule of law is simply not given the weight that it once was. One would expect that trends in judicial thinking would show up first in areas of law, like Aboriginal rights, that are primarily the product of recent jurisprudence. So this is perhaps an ominous sign for other areas of law. On that gloomy note, I will conclude. I didn't say anything about what might be done to address these problems, but perhaps we can get into that in the questions. Thank you very much.
Okay. Hi. So I brought my books with me. I'm going to be reading the books for 20 minutes. So, yeah, thanks for being here. As my colleague Malcolm Lavoie just said quite clearly, and that's the point I'm going to be focusing on in my talk, even though the Supreme Court of Canada regularly refers to Aboriginal legal orders as a source, whether or not we're talking about formal source of law or merely material or substantive source of law, the court says Aboriginal legal orders are a source of Canadian law. The court calls it the Aboriginal perspective. But as Malcolm said, the court doesn't really engage with these Aboriginal legal orders. We don't know much about them. But what the court really does when it says so, it's just showing obedience to the orthodoxy of the legal pluralism paradigm. And that's the topic of my talk. I want to talk about that so-called paradigm, and I want to investigate its relationship with the rule of law, the extent to which it might be compatible with the rule of law. So, to what extent is it possible for the same human being, person, the same jurist, to say, "I love the rule of law, but I love legal pluralism as well," the way some of my colleagues do. I'm not going to name the law school. The way I'm going to be talking about it is I will be talking about my book, which is an investigation into the claim from Aboriginal people's part for what they call the full recognition of their Aboriginal rights into modern treaties. Full recognition here means the opposite of the extinguishment of these rights into modern treaties. So basically they want the rights to be fully recognized instead of being extinguished. So my question was, as a young jurist at the time, I'm still not very old, how can this make legal sense technically? How can we negotiate a treaty that would recognize what is to be replaced? And my second question was how this claim, even if it is legally possible, is a claim to justice. How can we understand it as a claim to justice? I know there's a very long history of French Canadians struggling for the recognition of their civil law system. How is it a claim to justice? I'm still not sure. I'm not a big fan of the civil code. I have nothing against it. But how is this to be understood as a claim to justice? Why is it so important for someone to have his or her own legal system recognized? On the first question, the first issue, as soon as we understand Aboriginal rights, not as common law, Section 35 of the Constitution Act 1982, jurisprudential Canadian positive law rights, but rights that comes from non-state, traditional, customary legal systems, then it's really easy to conceive of a solution, of a certainty solution that would not extinguish Aboriginal rights as such, as the byproduct of non-state legal systems, but extinguishing rather the way in which the Canadian legal system recognizes effects to those rights. So the technical or theoretical answer to this is something that we were used to call legal pluralism. So we just have to realize that when Aboriginal people talk about their Aboriginal rights, they're not talking about the Canadian positive law, Canadian legal system. They're talking about non-state order system. Then it's possible. Like the solution, technically, from a technical point of view, is possible. But it doesn't tell us much about why or in what condition should a non-state legal system, be it Aboriginal or not, should be recognized. So is there any answer to that normative or more philosophical question in the legal pluralists' works, academic works? The answer to this is no, in my opinion, and the full demonstration is in the book. Yeah, I told my publisher I would, you know. And so when we look at all those main figures of legal pluralism, and of course I'm not the only one saying this or noticing this, Brian Tamana did so, we have a discourse on the law without any concept of what the law is. So much that in that discourse you could replace legal pluralism by rules pluralism, norms pluralism, or something like that, and it would make no difference. It would be the same difference. So it's a discourse that pretends to be descriptive and scientific on and theoretical on what the law is, but it's a discourse on the law with no concept of what the law is whatsoever. So it leads us, it gets us back to, let's say, like Hart's starting point, for example, according to which there's a use of the word law that is generally uncontroversial, but that can be sometimes controversial, so that it needs conceptual elucidation. It just leads us back to that. So there's no contribution. The only contribution on what the law is that's interesting that I found in legal pluralism, I found it in Santi Romano, whom no Anglo-American legal pluralists know about. So almost everything a legal and present-day legal pluralist says about legal pluralism, Santi Romano has said it in 1918. And what's interesting in L'Ordre Juridique, the legal order, which was just translated in English, I think 2 years ago, is the notion of relevancy. So the idea of what Art called operation of recognition. So the idea that a legal order may recognize effects to another legal order without that other order being part of the order that recognizes it. And I think Santi Romano did a much better job than Hart in theorizing this. But this has always existed in the law of the conflict of laws and the relationship between national law and international law. So we didn't need wait for legal pluralists. The law didn't have to wait for the legal pluralists to think about the operation of recognition between legal orders. So my point is, even if there's something interesting in legal pluralism theories, it's not the real contribution, because it's something that's been there for decades and centuries even. However, the legal pluralism works, even though it presents itself as a descriptive discourse, as a matter of practice, it's an activist, and it quickly takes a militant tone. It's like if the more legal systems we have, the more fun we have. Maybe for some lawyers, I mean, I can, understand this, but I've got way enough job for that. I don't need more legal systems for now. But so my point is, the very use of the word pluralism instead of sheer legal plurality. Plurality is a matter of fact, but pluralism suggests valuing a diversity and the bigger number possible of legal orders. So it is, in fact, a political discourse, and it is true that there are normative stakes. It is true that there are normative questions it poses, it raises. Jeremy Waldron had some form of timid intuition about this, but he didn't really develop on this. That's too bad. But it's true that it raises important question. why should we recognize, in what condition, what the consequences will be? And maybe we should get back to the question of the rule of law. Is the rule of law, or is legal positivism just a descriptive discourse, or is it a political project? Is there any, advantages and benefits in the distinction between what the law is and what the law might be? So all these are classical questions of legal philosophy, but legal pluralism take a stance about the law, not only with no concept of the law, but with no normative argument whatsoever on a normative issue. So then I turned to political and legal philosophy in order to find my answer. We are taught at law school and at graduate studies in law schools, and I think it's a feature of our intellectual culture. We feel like if we're facing a very complex legal issues, and there are, questions of justice, noble stuff like that, the answer must be somewhere in philosophy. It must be there somewhere. Philosophy is like that special knowledge, And so that's the way I thought, and that was my hypothesis in my dissertation, in my doctoral dissertation. So my hypothesis would be that I would find an answer to that question in the politics of recognition and philosophies of recognition. So yeah, I went to Germany. I learned to read German just to do this. I spent 10 years on this dissertation. I met with Axel Honneth and all those people. And seriously, I think I can say now that Taylor's Politics of Recognition really is a draft. It's a draft. And there's nothing in that paper that allows us to reflect on the question of the recognition of legal culture. So, yeah, Taylor talks about the recognition of cultures, but if you talk about the recognition of legal cultures, you have a very serious question, because if Taylor says, yeah, there can be a right to the recognition of your culture, and if you want to apply this to the recognition of a legal culture, then it means you have two concepts of the law. There's one law that recognizes, and there's one law that is recognized. There's the law as legal culture that can claim to be recognized. But if you have a right, if you're talking about a right, the right of a legal culture to be recognized, well, if it's a legal right, it means there's another layer of law. But I mean, there's no answer to this in Taylor. Just don't try to find an answer to this. Don't waste your time. I did it, and for you. So then I looked into much more detailed works on recognition in philosophy. So like these days, the main philosopher working on recognition is Axel Honneth from Frankfurt. He's now prof at Columbia. I think he shares his time between Frankfurt and New York. And the thing is, recognition from Fichte to Honneth through Hegel has always been about the recognition of the individual human being. It's been about recognition of its emotional needs, its cognitive capacity as a legal subject, and his or her social contribution and potential and skills. It has never been about the recognition of cultures per se. Then, Honneth, I think he felt like he had to try to accommodate the way his own works had been received in the Anglo-American world, because when his book, Struggle for Recognition, was published, everybody thought he was talking about the same stuff as Taylor. And that's evidence that a lot of people in the academia talk about books they've never read. And this I know for sure. But even though Axelon had tried to, he said, yeah, maybe there's a fourth principle of recognition, but I'm not sure yet. The future will tell us. And so it doesn't work. It doesn't work. So I did not confirm my hypothesis. So when I defended the thesis, the panel was almost shocked. I mean, they were stunned. What? You didn't confirm your thesis in law and human sciences. That never happened. That happened in sciences and other realms. But in human sciences, everybody confirmed his hypothesis. I said, no, I didn't. But then this led me back. So after years of being very interested into philosophy and thinking I was too cool for the law. It led me back to the law and the rule of law, because we have this. As a matter of fact, legal fact, if something like that exists, as a matter of positive law, Canadian constitutional law and international law both include or have or make operation of recognition towards Aboriginal legal systems. So we don't need legal pluralism. It's a matter of positive law. It's always it's in there in the law. So, but this is no answer to the philosophical question. So we know it's possible because it's in there. It's in the Canadian case law. So Section 35 refers to Aboriginal legal systems. The UN Declaration on Aboriginal Peoples, I know it's not a treaty, but it refers to Aboriginal legal orders as legal orders. So the operation of recognition is there. Now, I think it's important to keep in mind that we have to check and to have an idea on the condition under which international law and constitutional law already do or should recognize effects to Aboriginal legal orders. And I have two main limitations, so I will conclude with this. Of course, there's still a lot of work to do on this issue, but I think the two main limitations to operation of recognitions from state legal systems and international law towards Aboriginal legal orders are first, human rights, fundamental rights. I'm not a big fan of the theory that Aboriginal rights should prevail over, the Charter, for instance. And the second limitation is what I call a minimum core of judicial monism. So the rule of law always had both fundamental dimensions, one formal, one substantive. And I think judicial review and the idea that at the very end, any action that pretends to have legal effects should be reviewed by a system of general courts is something very important, so that saying I love the rule of law and I love the idea of the creation of an Aboriginal tribunal that has no connection whatsoever with the state legal system, I think it's a performative contradiction until I'm proved wrong. Thanks.
Thank you. That was awesome, both of you, especially. I'm definitely awake now. We will have some time for Q&A, so please gather at this front mic right here, and I'm going to bring this to.
Hi, I have a two-part question for Malcolm, if I might. So the first part, I would just say I think one of the particularly poignant critiques of the Supreme Court's approach to Indigenous property rights is that that approach doesn't even recognize the shape of property rights that Indigenous communities themselves would have recognized. Many Indigenous communities in British Columbia had private property, but the approach leaves no room for that. I'm wondering if there would be anything gained by identifying anything within Indigenous traditions themselves about respect for the rule of law or a similar kind of idea, and if that would, if you think there would be prospects of enhancing your critique through doing that. The second part, or second question, if I'm more honest about, is just you hinted that you had solutions, and I wonder if you could, in 60 seconds or so, tell us about those, or longer if Joanna gives it to you.
Two very good questions, also very challenging questions. I could answer the second part quite briefly by referring to your own work, C. Newman. In particular, in drafting this paper, I relied quite a bit on your paper on the economic characteristics of Aboriginal title and some of those criticisms, eco-criticisms that you've had. I think that's a great, the first point though, the idea of referring to rule of law values or analogous concepts in Indigenous legal traditions as a way of reinforcing the critique, I think is a really great suggestion. I can't say at this point that I've delved into that enough to have clear answers, although as you pointed out, particularly in British Columbia, these groups had well-developed complex systems of land tenure that presumably valued to a significant degree certainty with respect to those interests, and you can certainly see rule of law values there. In terms of specific ways to improve things beyond reading your body of work. With respect to the duty to consult, I criticize the decision to invent this doctrine or invent it as something completely novel. I think we're stuck with it now. One way of improving it, though, would be a kind of rule-based elaboration of the standard over time, as we're seeing with the Chippewas decision and other decisions. It's moving in the right direction. It may take a while, but judicial decisions that clarify what in particular terms are needed in particular circumstances can be quite helpful. In terms of Aboriginal title, that may take longer because it seems like claims are so few and far between, but there are ways in which the court could elaborate the doctrine. It could back off a bit from this language on encumbrances, on the inherent limit on use, recognize, as I think you mentioned, the idea that some of these groups have long histories under their own laws and institutions of granting subsidiary interests. And in fact, that's been recognized for a long time in Aboriginal title jurisprudence. In Johnson and McIntosh, the 19th century American Supreme Court decision dealing with Aboriginal title, it says all sorts of things that are problematic and potentially hostile to Indigenous interests, but it does say that it's possible for non-Indigenous parties to receive interests from Aboriginal groups that are recognized under the laws and institutions of the Aboriginal group. And so that's something that's actually been part of the common law jurisprudence for a long time. Returning to that would be one possible improvement. But there's a lot more to say, but I'll leave it at that.
Hi, this is a question for Maxime. Not recently, a year ago I read a paper that argued for a limited form of legal plurality between Aboriginal law and, I guess, Canadian wider law. The paper made the argument that with regards to petty crime that takes place on reserves, it would be more beneficial to those communities to deal with those crimes the way they would traditionally deal with them. So through community exercises, team building, sweat lodge, whatever you want to look at, that would enhance their ability to function as a society. And the argument stems from that to these communities, the concept of a state authority is entirely alien. And when a harm is done to someone in the community, let's say like a petty theft, then the harm is done against usually an individual and that small community. That's the frame of reference they operate from. And it seems like a completely unjustified event for an entity such as a state authority to come in and say that the harm was actually done to me and then to punish them based on that, meanwhile leaving the community unreconciled in a way. And I'm wondering what you make of that argument, because it seems your argument was that legal pluralism is very much it doesn't give any sort of normative concrete examples, and it is entirely an abstracted sort of argument that doesn't deal with what goes on the ground. So I'm wondering what you make of that.
So, thanks. So if I get it correctly, your question is what I think of the specific argument according to which the state has nothing to do with petty crimes that occur in Aboriginal communities. Is it this, am I getting it correctly, like this argument?
I don't know. I was just I was making an argument, I think, that stemmed from a justification. I don't know if you covered in what you were talking about, that the concept of a state is entirely alien in some places to these communities, and it's much more community-centered. And even if there is a leader, that leader is only a leader for as long as they maintain the respect of the people around them. So I'm wondering what you make of this sort of, I guess, limited concession of letting Aboriginal communities arbitrate their own petty crimes and deal with the consequences, punishments, reconciliation there.
So I want to express that I'm not against any form of legal plurality, judicial plurality, and, you know, self-governance. But I do believe that there must remain an irreducible element of review, of applicability and presence of the state legal system. You know, Hans Kelsen said that the law, the state law, is one part of social integration. And I think as long as we are going to share a same country, Aboriginal peoples and non-Aboriginal people, you know, the state isn't only bad. I mean, there has to be a connection, there has to be a minimum core of social integration, and reconciliation is about this as well, I think.
I agree.
And it has to be there somehow. As soon as we talk of a complete separation, then I think we're talking, it becomes antisocial. So yeah, I'm not sure if I'm clear enough, but.
Well, thank you very much.
I'd like to thank you both very much for your presentations. I love them. My question is primarily for Maxime. You seem at some level, and your answer to the last question, to not be completely opposed to some level of, whether it be Indigenous law or self-governance. I'm wondering, on the first level, would you conceive this as not dissimilar to the way that the provinces and the municipalities currently have certain laws and their parameters in which they are allowed to govern themselves, but in a broad constitutional order? And at a more profound level, there is a critique towards your thesis that fundamentally the Aboriginal peoples of Canada and the Indigenous peoples, they did not have this common law British legal system imposed upon them voluntarily. And at some level, no matter how useful it may be to have a reviewing court, it's at some level illegitimate or neo-colonialist. I'm curious how you respond to that critique. Thank you.
Thanks. Regarding the comparison with the provinces, I'll say it's tricky because regarding Aboriginal self-governance, we have to distinguish between many different cases, because in some cases we retain as a formula and a closed government, whereas if you take the Nunavut, for instance, it's really an open government, because we knew the Inuit would be majority and we just created a new federal territory. So provinces clearly are not closed and ethnic governments. Like it's more like the Nunavut solutions. I think like there's Ghislain, my colleague Ghislain Otis works a whole lot on this form of personal federalism as opposed to territorial. I think there are so many issues that are implied in the comparison that I can't like give a quick answer to this. But it's correct that I'm certainly not against some form of plurality and self-governance. There's something else I was going to say, but I just...
Legitimacy of the courts.
What was it? Legitimacy of the courts and...
That at some level, no matter how we
Oh
try
yeah,
to do this,
I'm sorry to interrupt
yeah,
you. It just came back. You know, there's a question of fact and the question of law regarding the relationships between legal systems or what one pretends to be legal systems. And I think the challenge in Canada is to shift from the factual relationship of what we call colonialism and domination, and from a more legal perspective, not only work on the condition under which the Canadian state legal system can recognize Aboriginal legal orders, but we have to work on the conditions under which Aboriginal legal orders, beyond the mere question of fact, can become willing to recognize and give effect to the Canadian state legal system. And I think this is a crucial and necessary stage we have to go through. This is a challenge we have to meet for reconciliation, but I don't hear many people talking about this.
So much food for thought in both presentations, primarily for Professor St. Hilaire, but if either of you want to chime in. Your comments, Professor St. Hilaire, about Section 35 and the necessarily hierarchical, in some degree, nature of the rule of recognition in that area, immediately what sprang to my mind, perhaps it's just me, but the 17th century prehistory of the rule of law in the Anglo-American system. The subordination of conciliar jurisprudence, conciliar courts to common law review is such an important part of that. The notion of legal pluralism and its internal inconsistencies, which you pointed out, I think, quite handily, does it depend to some degree on the notion of the rule of law as an essentially contested concept? And does it depend upon a certain forgetting of the emergence of the rule of law historically? If we reconstruct the rule of law, will there be perhaps some sort of impetus for more theoretical coherence? Perhaps a realignment from legal pluralism to legal plurality, as you suggested. Is that in the cards, in your view?
Well, I'm not sure I have like a full answer to your question, but I think the first step that's really important is that if we are to rethink the rule of law, or if we are to maybe get rid of the rule of law, because I'm not saying the rule of law is some sort of dogma, but I'm saying that if we are to get rid of it, we should do it after a very open, transparent, and conscious discussion. So that's my problem with legal pluralism, because it might be suggesting, it might be doing normative claims about the rule of law without really addressing the issues. And one might wonder whether or not like some authors are really conscious of what they're implying regarding the rule of law. But then, if we want to have a conversation with Aboriginal peoples, as I just said, if you want to have the conversation about the condition under which the rule of law might be a good for them, and we want to maybe revisit or reform the rule of law, let's do it. But let's do it, let's be aware of what we're doing instead of, saying the more legal order is more fun.